case briefs, and so much more. LSData's got what you're looking for.
In a 2009 case, Oakley Fertilizer Inc. v. Continental Insurance Company, the Missouri Court of Appeals dealt with a dispute between Oakley Fertilizer Inc., the seller, and Continental Insurance Company over a damaged shipment of fertilizer. The conflict centered on whether there was an agreement between the two parties about who was responsible for the shipment's insurance and the transfer of title and risk of loss. The trial court had granted summary judgment in favor of Continental Insurance Company, but the seller appealed the decision. The dispute stemmed from a sales contract in which the seller offered to sell fertilizer to Amaropa North America, the buyer. The contract stipulated that the transfer of title and risk of loss would occur after the seller received good funds from the buyer. The buyer sent an electronically signed purchase agreement that did not mention the sales contract and contained a different risk of loss term. The court applied UCC Section 207 to determine which term controlled the contract and found that the buyer's purchase agreement constituted a valid acceptance of the seller's offer, forming a binding contract despite the different risk of loss term. As a result, the trial court's judgment was reversed, and the case was remanded for further proceedings. The appeals court also rejected Continental's alternative theories in support of summary judgment, stating that the insurance company failed to prove that other parties insured the cargo or that the seller was required to provide timely notice before making a voluntary payment.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.